So the seminars that we do are really important to most people because they need to know how to wrestle control back from the government. It's not just for rich people. Well, you've got to come to these seminars because right now people don't realize that by not doing that, you are naked.
The statements expressed in the following program are those of the speaker. They do not necessarily represent the views and opinions of the sponsor, the host, and/or Olas Media.
Olas Media.
You're listening to the Lawyer in Blue Jeans podcast.
Welcome to the Lawyer in Blue Jeans podcast. My name is Justin Isaac. I'm joined by Jeff Isaac, the Lawyer in Blue Jeans, by Chad Peace and Steve Peace. We are talking local, voting politics, voting rights, and local lawsuits being filed. Chad, why don't you tell us a little bit about the lawsuit that we were just talking about?
Oh, we're jumping right into that.
Well, why not? Why wait?
This issue comes up every 4 years in the state of California, which nationally champions itself to be the great protector of voting rights. And the case that we filed on behalf of the Independent Voter Project, authored California's nonpartisan primary almost 15 years ago now, is relatively simple but also complex. Is that we have a presidential primary every year that the Democratic Party and the Republican Party choose their nominee for who's going to represent us. And it looks like it's shaken out to be that two-sided debate again today where everybody's super happy about the candidates on both sides. But the issue in California is that you have ballots for Democratic voters. You have ballots for Republican voters. And with automatic absentee balloting, Democratic and Republican voters are getting ballots that have all the races and then the candidates they can choose for president. But when it comes to independent voters, which are now 6 million independent voters in the state of California, they're literally delivered a ballot, unless they jump through a bunch of hoops, they're literally delivered a ballot that has candidates for every single race, and then for presidents, a blank box, right? So our lawsuit is saying...
Well, why don't you do this before you go further on that? I think it's important to talk about what the definition of the way people can vote is as far as open primaries versus closed and all that. I think that's important.
Yeah, it's important. It is esoteric and confusing. Kind of the point of our lawsuit is voting should be pretty easy and it shouldn't be esoteric and confusing to voters. But an open primary in a lot of states, the definition would be it's open. The door is open. Anybody can walk in it. There's no sign that says only walk in here if you're a Republican or Democrat.
And you can cross over. You're not stuck, right?
In a fully open primary, right? You can walk in through any door you want, right? Now there's different iterations. Like a semi-closed primary means it's open, but if you're a member of another party, you can't go in there. Then you have closed primaries. The door's shut. Unless you're a member of that party, you can't go through that door. You have semi-closed primaries, which is the way California conducts its presidential primary. The door is shut, semi-closed, unless the party has said, you know what, you can go ahead and open the door for these independent
The party
voters.
Meaning the Democratic Party.
The Democratic or Republican Party. So when it comes to California, we actually don't know who's going to let the voters vote until 4 or 5 months before the election. Because the parties don't have to decide whether to allow voters to participate in their primary until 4 or 5 months before the election. We go based on historical record that we assume the Democratic Party is going to allow NPP voters to participate. The Republicans won't. The Libertarian Party will.
Why don't you give a definition of NPP, please?
NPP just means no party preference. It's the colloquial term is independent voter, right?
Which is a growing segment of all populations in every state, certainly in California.
In California, there are almost 6 million. They're floating around Republican registration, despite the fact that if you wanted to vote in the Republican primary, you'd have to register as a Republican voter. States like New Jersey, they're 50% of the vote, and they can't vote at all in the primary. So
that's insane.
Yeah.
So that's so crazy to think about that. This is a fundamental part of the voting process, yet states and, well, I guess the two-party system is really the ones who set the tone and made the legislation, the laws this way, right?
Well, I think this is historically, right? It was over 100 years ago, really, during the I'm using the term as it originated, the great progressive era is when they brought primary elections into the public process. Over the last 100 years, and my father, Steve Peace, can chime in about some of the ways things have changed, including relatively recently, is that they brought the party nomination process into the public process so that it was more transparent, so that voters had a say, and that the people didn't think, these nominees are just getting selected back in smoke-filled rooms, right? Skip forward to today. Yeah, we have an election process, but I think the average voter would be like, those candidates, those winners were actually determined by somebody else, and I'm just going out here to symbolically vote. Our lawsuit's saying in the case of no party preference, independent voters, they're not only can't come out and vote, right? The rules are preventing them from doing so.
So who are the losers on that? Steve Peace, I know you were part of the legislation involved in a lot of this in your time in Sacramento. How does this affect, and who does it affect people?
Well, anybody who is an NPP voter, right now, assuming the parties make the same decisions they've historically made, only gets the opportunity to participate in either the Democratic or the Libertarian presidential primary. But even to do that, they have to select a ballot. They get a ballot in the mail, but that ballot will be wrong if they want it, and they have to go say, hey, send me a second ballot. Ironically, I'm the author of the legislation in the year 2000, SB 28, that created that choice. But in the year 2000, we had partisan primaries, and they, in fact, had just been restored. We had a brief moment where we had blanket open primaries, and the Supreme Court in Democratic Party v. Jones overturned that, saying that the political parties have what's referred to as a private right of association, meaning they get to determine the rules of who gets to vote. So we now have a circumstance in which, and then you fast forward 10 more years later, in 2010, Proposition 15 is passed, a constitutional amendment in California creating the nonpartisan primary system we operate on today, and everything except the presidential primary. Now, why would we have done it that way? Why does the Constitution simply say we'll have nonpartisan primaries or presidential primaries? Well, we can't, because presidential primaries are different. You're not actually electing somebody. It's really just a big poll. And the parties are not obligated to pay attention to the poll. They adopt their rules after the election occurs. And they if they wanted to, they could say, we're going to do the opposite of whatever the voters vote for. They can literally say anything they want to say. So but the election's a public election paid for with public tax dollars. So the state puts into statute the rules. In the case of the Democratic, I and Ross Johnson was since passed away, but he was a Republican member of the legislature. I, as a Democrat, Ross, as a Republican, wrote the statutory language that was put into effect after that court ruling, throwing out a roll blank primary. And we said, okay, if a party decides to allow a nonpartisan voter to vote in their primary, we're going to put provisions that say they have to say to the registrar of voters, send me one of those Democratic ballots. Now, behind the scenes, that was because that's what the Democratic Party wanted. They wanted to allow voters, but they wanted to make sure they collected it. Even in the analysis of the bill, there was a suggestion in the analysis that this might be a problem. They said, what about absentee ballots? It's right in the analysis right there. We purposely didn't put any specific language as to that. We left it up to the Secretary of State to solve that problem, because at the time, absentee ballots were less than 2% of the total amount of people voting. It wasn't that big a problem. We said, Secretary of State, you can deal with that. It's regulatory. And we also purposely kept the language broad to give the Secretary of State a lot of flexibility, because we knew the world changes. So how has the world changed since then? My language that I wrote now has the discriminatory consequence of discriminating against younger voters, black voters, Latino voters, Asian voters. Why? Because in each of those categories, they are disproportionately represented as NPPs, in particular younger voters. So we go from a world in which we used to have older, high-propensity voters who got these absentee permanent ballots, from a world in which they're overwhelmingly low-propensity voters. Now you add another change, which is ballot harvesting. We've now legalized ballot harvesting in California. So do you think
Why don't you define that real quick?
That's
I
where
think a lot of
people get paid to go out and collect ballots and bring them to the register our voters in big bundles or drop them in the mail. So
And that's legal.
it's legal. Political operations by candidates or by parties or by labor unions or anybody else, a business could do it. They go out and they do that. Now, if you're part of the partisan in-power infrastructure, you think you're going to go out and collect ballots from NPPs? You're going to ignore those people. They're unreliable. You don't know what they're going to do. Now, look, I supported Hillary Clinton in the primary election when Bernie Sanders was challenger. But if any of us who were with Hillary Clinton, if we're truthful, we got to tell the public the truth. The Bernie Sanders campaign was devastated, was wiped out by this provision of law because it was so complicated and so difficult for them to reach out to the large number of younger voters who were eligible to participate in the Democratic primary but had to get a second ballot. And by the time the Sanders campaign got to California, had to think about, okay, what are the rules in California? We've been in North Carolina, we've been in Hampshire, we know all the rules there, and there's a different set of rules. And they say, wow, look at this rule. We've never seen this before. They may very well have won the California primary if the rules hadn't been rigged, and they are rigged.
So what you're saying in Blue Jeans talk, as we like to coin it, it's an undue burden. Would that be fair?
If a southern state adopted these exact rules, the ACLU would be claiming that this was a conscious effort at voter suppression. That's how egregious.
But it's an extra burden of the citizen to actually have to go through hoops that the others do not have to go.
Don't.
So it's discrimination.
But just to be clear, this is not purposeful. This is just the actual net result as being used by the party.
I would say that the inability to fix or the inaction to fix a known problem that is nationally recognized, now that has become purposeful.
Gotcha.
The political operatives know exactly what they're doing.
Yeah.
Is the court who looks at this, they don't, they've never gotten to the point of an evidentiary hearing to actually look at the issues I'm laying out. You take a piece of statute that made perfect sense when it was passed in the year 2000 and did not have a discriminatory impact. And as the author of that statute, you can imagine the angst I have in seeing statute I wrote having the most discriminatory effect amongst the most, what I would argue, the most important group of voters, younger voters, who are acclimating to the process, and then you throw them into a system that they find to be difficult to get over those hurdles, as you described. So what do you think happens the next time they go out to vote? They just don't do it.
Right.
They get discouraged and they quit, and they get cynical about the system, and then we wonder, why? And does the Secretary of State's office understand what they're doing?
You're talking about primaries now. You're not talking about the general election.
Presidential primaries.
Right, but again, I want to make sure we distinguish that. It's not the general election where that doesn't come into play.
Correct.
Right?
Correct.
It's primaries where they're picking theoretically nominees, and it's shutting out.
And look, understand that under Democratic v. Jones, if the court rules properly ultimately and says, hey, look, this is clearly unconstitutional under California's open primary, and it's also in violation of a variety of federal rules, the political parties would have the perfect right to then say, okay, that's fine. They could rewrite their rules.
Right.
And under their rules, they could say, we're going to have two classes of voters. Now, nobody's ever litigated that.
And I don't think it'll stand to scrutiny. But
exactly. And they don't. That's part of what the Democrats, my Democratic Party, I'm a lifelong Democrat, but let's just tell the truth here. The Democratic Party wants the legislature to do its dirty work and to cover up for the fact that they are protecting voters and a structure inside the Democratic Party that is embedded in terms of the leadership. They don't want to lose control of the party to combatants on the other side. Now, I've typically been closer to those people that are making that argument. The irony is I'm a guy, like I said, I was not with Bernie Sanders. I was with Hillary Clinton. But any person who was on the Clinton side, who also enjoyed the benefit of the support of the Democratic Party infrastructure at the time, right, who tries to tell you that they didn't knowingly allow and rejoice in these barriers that made it difficult for the Sanders campaign, is simply not telling you the truth.
Now you've not been successful, right, Chad, in court. They've literally summary judgment you, or is that what did they do on?
Well,
your
yeah,
court
we're
proceeding?
still been dismissed on summary judgment. Like any good attorney, I redefine success as we continue to get dismissed, right? But no, I mean, it's all been ruled on a matter of law right now. In the case that my father keeps referring to, Democratic Party v. Jones, is a matter of law. The Supreme Court said political parties have a private right of association, and therefore the state can't have rules that force the party to associate themselves with other voters, like NPP voters, right?
But, sorry to jump in on that too. Since we are funding it publicly, wouldn't it make sense that the state would have some authority? Go ahead.
So here, this is exactly to my point. We're asking a different question. The questions that came to Democratic Party v. Jones, and if you look at the Nader case, which was a similar case out of Connecticut, which they used to dismiss our case, have always asked a question. Does this independent NPP voter have a right to participate in the Democratic Party's primary or the Republican Party's primary? Mm-hmm. To the best of our knowledge, we are the first people to ever ask the court. We're not asking to vote in their primaries. We're saying a more fundamental question. The state has set up this process. They pay for this process. They administer this process. Doesn't the state have a responsibility to allow an avenue of participation for the NPP and the independent voter, right? It's a broader question. Mm-hmm. What's the state role? So to your point, we've been dismissed on summary judgment because they're applying a question that's relevant, but it's not
on point.
It's interesting. As a non-lawyer, I go and I read the brief submitted by the Secretary of State, and I read the court decision and then the appellate court decisions, and the plaintiffs ask, "Is the sky blue?" The Secretary of State's lawyers say, "The sky is not green, Your Honor," and the court says, "You're right. The sky is not green." They literally, neither the court nor the Secretary of State's attorneys even remotely get close to even discussing the question that's asked.
Okay, so it sounds like an equal protection issue, right? Is that part of it?
That is one of the claims, yeah.
Okay. I have been discussing over the years on radio and so forth the ACLU. They usually fight these battles, right? Whether you're right or left, it doesn't matter. They fight for, the Constitution and for people to have their say. That's really the bottom line here.
Yeah.
So where's the ACLU in this matter? Have you gone to them? Have they wanted to get involved at all? It seems like people love to hate them. I get that, and I'm one that says these guys are really important. I've always said that. So where are they? Have you reached out to them? Have they involved themselves? Where are they?
Do you want to? We had spoken with some local representatives. We filed our issue-setting case back in 2015 in New Jersey, and at that time, I had some conversations with folks from the ACLU, and really the response hasn't been, "Oh, we disagree with that," or this. It's just, their voting, the people they've put on voting rights are tasked with a set of lawsuits around voting rights, a lot of it voter ID related and that stuff. And we're not making any judgments on the merits on those cases, but that's where their attention is. Mm-hmm. This is so outside of where the focus is.
This is, ironically, it's so simple that it gets, I don't think...
They obfuscate it.
90%,
it sounds like it's obfuscated.
Look, at 90% of the people on the periphery of the discussion or even in the discussion, including the court and the Secretary of State's office, literally, they have no intention to have the deleterious results I've just outlined. And you find this a lot as a legislator. And with all due respect, you lawyers have bigger problem with this than non-lawyers. Lawyers tend to zero in on trees and often miss the forest. And it is in part because they're trained to be focused on case-based precedent, right? What we've seen here is very simple. I wrote a law creating a tree. in the more than a decade since I wrote that law and participated in negotiations with representatives of the Democratic and Republican parties and a variety of other folks, including the ACLU, as a matter of fact, the entire forest changed. We had passed a constitutional amendment changing the way people vote in all other elections. We created a 100% mail ballot dynamic. We legalized ballot harvesting. Nothing about the basic forest that the trees live in is the same as it was when I wrote the bill. And that's why I made reference to that simple little sentence in the bill analysis. The bill analysis says flat out, hey guys, look at this. This system won't work very well for permanent absentee ballots. Maybe you should do something prescriptive about permanent absentee ballots. We didn't because they were such a small part of the overall element of it.
But
now,
you didn't put any provisions in there that, like the what if issue.
we did the opposite. We said, hey, Secretary of State, we're not going to do anything real specific here because you can adjust as times change.
And they haven't.
And they haven't. And that's the problem. And I think they genuinely don't think. Now, there's a certain amount.
Is it they don't understand or they want to keep going the status quo?
I think some people genuinely don't understand and some people choose to appear to not understand.
Okay, fair enough.
I think that, I guess once we get to this point now where we have this huge group of independent voters, Chad, you said 6 million.
6 million.
Which is almost equal to the registered Republicans in the state.
Correct.
And so as a percentage of total voters, do you know what that is?
It's 25% of the electorate.
Something like that. That has to make this case. How many more people are being disenfranchised now, which you said are disproportionately minorities?
And that goes to the broader question. There's actually two distinct components to this lawsuit. I, of course, tend to be emotionally fixated on, I don't want to be the guy that is the author of language. It is amongst the most discriminatory language in the current environment in the entire United States. It has the result of suppressing more votes than probably any other piece of statute in the entire country.
Yeah.
Right? So I feel strongly about that. But there's also a broader question here, which you go to, is that once you decide you're going to have a publicly financed primary, which all of us as voters finance, irrespective of whether we are registered in a party, not registered in a party, or not registered at all, do we have an obligation to allow voters who choose not to join a political party to be able to express their preference? The court, interestingly enough, argues, well, no, because that would be deceptive to the voter because it would be just expressive, that there'd be no consequence, no value to the vote. Well, that belies a simple fact that the court doesn't understand, that every single person who votes, whether they're a member of a party or not in a presidential party, is doing an expressive vote with no legal consequence. If you're a member of the Republican Party and you vote for Mitt Romney and Mitt Romney wins the Republican primary, there's nothing that compels the delegates that go to a convention to vote for Mitt Romney, not even the delegates in California, let alone the entire party nationwide.
So, sorry, if I can jump in, because you said the case Democrat
Party v. Jones.
Okay.
Right.
So if they said at that point that the parties have the right to make their own rules, and the rules are arbitrary, because that to me says that if someone is voted in, if someone wins the vote, and they still have they could still, in theory, choose not to elect.
That's exactly right.
So is that not arbitrary? Where the rules don't even matter.
So well, here's one of those
From the
classic
state
examples.
size, they don't.
No. Let me go. This is I always found this to be the most difficult part of legislating.
Mm-hmm.
So it's hard enough to get by in the world. On top of that, not being paid right by your employer and being cheated out of overtime, being cheated out of the hours that you work, it's not fair. And if you're going through that, it's important to seek help. At Summer Shorts, they've helped thousands of workers just like you and me to recover over $100 million of unpaid wages. Go to summerspc.com to sign up for a free case evaluation.
Often, in order to understand the choices, you have to skip all the way to the remedies.
Yeah.
Right? If you get bogged down in just debating over the problems, everybody has their view. They're looking at their part of the elephant. And if you don't understand what the limits are with respect to your remedies, you're in a perpetual conversation. your question goes right to that. And I think this is the part the court's missing, and the reason why you need an evidentiary hearing. You can't get to discussing remedies if you don't get to an evidentiary hearing, right? And there's a third element of obligation under the law that none of us have discussed. That is, whenever, no matter what subject you're speaking to, if you're trying to remedy a problem, you have a legal obligation to remedy it in the least restrictive way. You have to do your best not to cause other problems while you're solving this problem. Mm-hmm. The easiest way to understand the challenge for the Secretary of State's office as it relates to open primaries and Democratic Party v. Jones is what's the least restrictive way to meet the obligation to respect the political party's right of private association as articulated under Democratic Party v. Jones. And there are a number of less restrictive ways to respect the right of the parties without eliminating the ability of independent voters to have the right to vote in the presidential primary. I'll give you the easiest one. Color code all the ballots. Then let the parties count who they want to count and not count who they don't want to count. It's simple. Everybody gets to vote. If the Democratic Party doesn't want to count NPP ballots, they don't. If the Republican Party only wants to count left-handed ballots, then we'll have to color code left-handed ballots. As long as you know the rules and the distinctions of all the parties, it's easy to color code the ballots. And there are other remedies. All of them are less difficult, less expensive, less complicated, less confusing than implementing the statute I wrote.
So it seems to me that we've got a bigger problem than that. I think the issue becomes not the new. I don't want to call this a nuance, but I mean, in a way, it is. It sounds like the whole system is messed up. I mean, the whole system of the Democratic Republican primaries and the arbitrariness of picking what and choosing what. I mean, it almost goes to the general system that we have in our country with the Electoral College. It seems to me that the system is just broken. I mean, again, as just somebody who's not political in nature, I mean, you've been, you may not be a lawyer, but obviously you've got a significant touch on this stuff way more than I do.
So let's look at that. The question then, system, what is the system? The system starts with a bunch of laws, and then it has a bunch of regulations, and then it has a bunch of human beings implementing the regulations, attempting to implement the laws. In this case...
Well, I think you start with the law, but go ahead.
Right. Exactly. That's about what I was going to say. In this case...
The pillar.
We wrote a law. We purposely were not prescriptive about the law because we know the world will change. We subsequently had a constitutional amendment going from a partisan system to a nonpartisan system. And the Secretary of State's office, under two successive Secretary of States, has failed to implement the law. They don't need any statutory change. Everything I just described, color coding the ballots, for example, was actually in SB 100, a bill passed just prior to SB 28, authored by then Senator Burton. And that actually allows for the Secretary of State, and actually dictates that the Secretary of State look at color coding for clarity in terms of ballots. The Secretary of State can remedy this tomorrow. It doesn't require statute. It's simply, and what we're trying to do, in what I'm trying to do in my letter, is to argue on my specific point that, hey, look, at least fix this. If you're not going to fix it for the NPP question, to your point, a broader issue, then at least go fix the ridiculous implementation of a statutory paradigm written at a totally different time and has the opposite result.
So let's talk about where you're at now, because again, this is all important information, I think, for every citizen, and certainly in the state of California. But you've lost every round in court, all right, understandably for reasons that you've enumerated. What are you doing now? You mentioned off air that you were in the process of writing a letter. Would that be a petition to whom?
Well, no, they have the original litigants are appealing the appellate court decision at the state Supreme Court. That appeal is at the court. A number of organizations have filed amicus letters supporting that petition. I'm writing a letter. I've written a letter
to the California
Supreme Court as the author of SB 28.
Independent of
as an amicus letter.
Correct.
It's an amicus letter, right? So where are we at? We've we lost at the district level. Okay, got an appeal. The appellate court dismissed on summary judgment. We just filed our writ to the California Supreme Court, the petition letter saying, here's novel issues, here's all the reasons why the Supreme Court should consider this case. That's where we're at.
And they have not taken it up yet.
They haven't made a decision. We've got, some national organizations, open primaries, fair vote. Former Congressman Tom Campbell filed a letter in support. And obviously, my father filed a letter in support.
Which is significant because if it comes down to anybody,
the author
with intent would be the author of the legislation. I mean, obviously, that's
right.
One thing I don't mention in my letter, but which is there in the public record, the constitutional amendment passed by the voters subsequently, I literally physically drafted. The legislature put it on the ballot. I wrote the words. So I am both the author of the state's constitutional requirements, which I believe, to your point of systemic reform, already fixed legally the problem, which is the reason why we're suing. So, Chad, I assume if you lose at the state, what do you do assuming you lose at the state?
We have to see what happens here, but it's important to understand we're not even, right now, we're not at the stage of saying Supreme Court rule agree with us.
Yeah.
Our whole case is, let us have an evidentiary hearing.
Yeah.
We may ultimately still lose, but we can't even have the conversation we've had here today in court because they're taking a law that's relevant but not on point to say it's not even worth a conversation.
But for a summary judgment to be in effect, there's got to be some informational background or basis that the court has evoked. I mean, there is evidence
that was my
in
point.
front of them. There has to be.
Right. But if you read the court cases, the best way to understand how the court got to where it's at is to read the defense briefs prepared by the lawyers in the Secretary of State's office. Any reasonable person, law professor, clerk, anybody reading these documents would read the documents submitted by the plaintiff, read the documents submitted by the lawyers of the Secretary of State, and say these are two different cases. I want to see the one. And I get it. I've lived in that space, and what happens is that all the lawyers that work for the state, this is all coming out of the Attorney General's office, right? They practice in a very narrow space. Some guys do franchise tax board work, some guys do elections work, and they're inside the orbit of the narratives and the decisions that have been made in the past. This argument that's being made is a case of first impression. It is brand new, law. They just aren't thinking through it. It's just that simple, which is why you got to get to an evidentiary hearing to help them understand what the question is.
It's called laziness. It's called I don't want to get involved. I mean, we see that.
I think it's more that I don't want to get involved than laziness is right.
Well,
especially
I think
if you're a district level judge or even an appellate judge. I mean, this has a substantial consequence on the political discussions and saying, hey, look, we got to kick this up higher.
I'll make some comments that I probably shouldn't make. I'm Senator Padilla, who was previously the Secretary of State, was a close friend. I understood why he didn't want to get into it because he was angling to be appointed to be a United States Senator, and the National Democratic Party really doesn't want to have this dealt with. I am a little surprised that my other, even closer friend, now Secretary of State Shirley Weber, hasn't waited, but she hasn't personally waited. I think if the Secretary of State was personally engaged in seeing this and understood what her lawyers are arguing and understood what the consequences in her community and her constituency are, she'd change it in a hot second.
Well, that sounds like a political decision.
The Secretary of State's office, like many of our areas, are run more by the bureaucrats than by the, and they they're a perpetual motion machine. And until so
it's a political bias.
So to your point, you said, well, what are you going to do next?
Right.
I don't know what the litigants are going to do, and I don't know what they live in their space. I fairly recently came to the conclusion I need to step up. I haven't said anything publicly, in part because these people making these egregious decisions or non-decisions are my friends.
Yeah.
They're all people I know very well. And I kept thinking they were gonna say, "Hey, wait a minute, this is just wrong. It's ethically wrong. It's not legally wrong." And so the question then is, what happens next? You asked at the point of this. Well, you're going out and doing publicity. We haven't because we're being respectful to give the opportunity to the people in the process to fix it.
Sounds like you haven't. You've already exhausted enough where maybe the public, or at least certain segments,
we will be
involved.
I will, at least on a personal level, become more vocal, less respectful, and
Well, I think you can be vocal
urgent.
and respectful at the same time.
Well,
but
I'm
I
going
think
to
you have to be
respectfully. I will tell you what we're
perfect.
going to do. Once we get a court decision, I'm going to respectfully go to the legislature and say, well, the court apparently thinks it's okay to have a statutory regime that clearly results in voter suppression, and I'm going to ask the legislature to amend the statute and to expressly direct the Secretary of State to do what the Secretary of State should be doing.
Got it.
I was actually going to ask that question too, because you said that the Secretary of State could easily remedy this, fix this
Tomorrow.
And why not? What is it? A writ of mandamus compelling? Is that not an option, or some kind of?
That's essentially what our lawsuit is asking for.
But say
right?
that doesn't even work. What about, is it even possible to put something on the ballot where people can vote on a change?
If you have $15 million, you can. So I would love some folks that are billionaires to look at these kind of issues and say, look, you're sitting here spending $20 million to fix this little thing. Here's the thing that's fundamental to
That's
our democracy.
why, as I mentioned to Steve, the public pressure, and you know that better than anybody. I mean, being a member of the legislature, may or may not have something to do with that. In other words,
Well, it does.
sometimes it's time. You can be respectful all you want, but I like to think I'm respectful in what I have done over the years on radio and TV. But at the same time, if it's wrong, it's wrong.
Well, I think what he's saying is not. It's more of like the courtesies being extended.
I understand.
And the courtesy is going to go away pretty soon because they're not extending any courtesy.
And look,
back.
it's harder and harder to have public input. I don't like the word pressure, input into the political process. And this would be true if it were a predominantly Republican legislature, or as much as it is a predominantly Democratic legislature. Anytime you have what in effect is a one-party state, it's difficult to have a competitive intellectual conversation.
Wouldn't that be the issue, though? You just mentioned it. I mean, we are, in effect, a one-party state, but more and significantly so, I think, in today's world of nationwide, if not California, it's becoming more than that. The party system is under major scrutiny, with independents growing
for good reason.
hugely.
But that's part of why you'll see. Look, at the Republican Party still has not moved. All of us believe that by now the Republicans would have figured out that it's just bad business to not let independents vote in your party, and yet they continue
Right.
to shrink themselves.
They
by
exclude, yeah.
right. This is literally like being in business and telling 2/3 of the electorate, I don't want to sell you hamburgers, right? And I get it. I understand that inside they worry about what they view to be an intellectual purity of their process. But we live in a system that is not a parliamentary system that rewards narrow-casted political parties. The evolution of what we call a two-party system was accidental. It wasn't the intention of the framers of the Constitution. They had hoped to avoid what they called factions from evolving at all. That didn't happen. But the difference between American political parties is to be effective over time, they have to have very large tents. And the coalition building occurs in the formation of the parties. And kind of what's happened, to your point, as the way we communicate changes, and the hyperbole that is endemic to our means of communication, commercially, politically, socially, and otherwise, permeates the system. That two-party system gets the whole concept of two big tents, and occasional movement has been broken down and kind of made obsolete by virtue of the hostile nature of the public communications. And so it's a bigger problem, and it's a challenge for all of us. It's the reason why, when I left the legislature, the only political thing I continued to participate in was the elimination of our partisan primaries. And that is the single most important thing we can do in this country. It can never be effective until we get to a critical mass where most states have nonpartisan primaries.
What would be the effect, and I know are we starting to run out of time here, but what's the effect of the fact that the independents, quote unquote, air quotes, are on this are significantly going up? In other words, there's a huge rise. Is there a critical mass at that stage that will dominate? And I don't know that the independents are going to outweigh the Democrats, but
only when there is enough systemic change, and that's why Chad's organization is part of national organizations that are changing the systems in states throughout the country. Alaska just adopted top 5 or top 4 ranked choice open primaries. You will see similar efforts here in San Diego for the city of San Diego and others. And that's a whole dynamic to try and bring together the two big reform movements in the nation are ranked choice and open primary. Okay. And it's a marriage of those two things. And if we can keep the reform community together, the critical mass gets to the numbers where we can flip enough states that eventually we could get there, but that doesn't happen overnight.
Yeah, but I think we go from 10 years ago, we had these conversations. I used the term esoteric earlier. There's 5 people talking about this in a corner, right? Mm-hmm. And it seems still there's a long ways to go, but there are organizations. I'm leaving Monday morning to go to a 2-day board meeting with organizations that this is the issue that they focus on. You say, what's next after this lawsuit? We got into it. We filed our original issue-setting case in New Jersey almost 10 years ago now. I can't believe it's been that long. But take New Jersey, where the independents, they do outnumber the Democrats and the Republicans. They're 47% of the electorate, and our argument is, by law, they can't participate at the first integral stage of the election process because they've exercised their First Amendment right not to join a private organization, right? So we're sitting at a writ of certiorari to the United States Supreme Court there. Right now, we just filed our writ petition to ask the California Supreme Court. It's a 30-year. What's next is, well, maybe it's going to be 7 cases. Maybe it's 10 cases. Maybe it's 20 years. Maybe it's 40. But at some point, we know a common sense, you can sit down. You don't have to be an attorney. This is discriminatory. This is not.
I think it does keep going to that word, critical mass. I mean, it's just a matter of, unfortunately, it's way too slow for too many people.
And look, as the non-lawyer trying to pretend to be a lawyer on a regular basis, my dream is to look right into the eyes of that Democratic Party v. Jones decision and go, look, your argument here is that a private right of association gives these political parties the right to dictate the terms of their voting, right? Well, and I agree with that, but if a political party, an organization, the Lions Club, whoever it may be, they only get the private right association as a derivative of each individual's private right. And if we are going to penalize the individuals who exercise their private right of association by not association with a political party, and that has the consequences they can't vote, under Democratic Party v. Jones, you can't do that to individual citizens.
Right.
The compelling argument is, at the end of the day, do you have a right to vote because you're a citizen of the United States or not?
Bingo. That's
actually a pretty good thing to end on, I'd say.
You're right. I wish you all the luck, both you guys. I really do. I think that it just, sometimes things are so common sense that people lose it in like you say, the forest. I mean, it's just for many reasons, and some intentional, I would suspect as well.
So, Chad, Steve, how can people get involved if they actually are wanting to? Can they donate? Can they support? Can they write letters? What do they do?
I mean, all of the above, but go to independentvoterproject.org and you can see what we're doing here in San Diego. We have a reform we're working on, this legal case. Obviously, donations are more than welcome. It's not an easy task, and believe it or not, there's not an incredible amount of dollars that are pouring into these types of lawsuits and reforms. Let your council member know. Let your legislator know. Say, hey, that the stuff the Independent Voter Project's working on, I agree with it. I think you should make that a priority. We have a lot of legislators that do agree with us, that want to see our success, and they understand we're not anti-party, we're not anti-politician, we're for a better process. And so the more people that can stand up and say, you know what, I agree with that too, and my legislator should think it, that's how you get to the critical mass, is by saying, look, it's safe to be supportive of these issues because they're right.
Yeah.
I think it comes down to the simplicity of this, even though it can be very complicated in the rough here, is should more people be able to vote or less people? I mean, it's just
exactly
that,
right.
Yeah.
Exactly
it just
right.
comes down to that.
And
how can anybody in this country, let alone the state, argue that, the fewer the better? That's democracy?
The ultimate irony of my party having the broad argument that we should not have barriers to voting, and then secretly using the government
They're all the
to
same, buddy.
create a barrier of voting for just a select group of people. And let's be clear, why do they want to have that barrier? They're afraid of them. These are young voters. They're unpredictable.
And power.
They don't know where they're going to go.
They don't
right?
want to lose their power.
And look, I'm not a person that necessarily philosophically has nothing to do with me supporting one of those group of voters or another group of voters. I'm just on principle.
Right.
If you want democracy to work, it has to be fair, open, and competitive.
Yep. I'm 100% in on that.
Well, that was about 45 minutes. That went pretty quick. Steve, Chad, thank you very much for joining us. A lot of great information here, and hopefully we get some people involved, and hopefully we keep going and maybe win, maybe get an evidentiary hearing. That would be a good
That would
start,
be a
right?
victory.
Yeah.
We're not asking for much.
Just a fair hearing. That's something that sometimes people don't get.
Well, thank you everyone for joining us. This has been the Lawyer in Blue Jeans podcast, and we'll see you next time.
Take a break from the news and join us at Lawyer in Blue Jeans. If you're curious about the latest wacky cases or have a specific legal inquiry, drop us an email at justin@lawyerinbluejeans.com. Follow us and subscribe to stay up to date with our latest episodes.
This episode was produced by Olas Media Podcast Network in San Diego, California, with Elia Ramos as creative director, Jessica Garcia as project manager, JC Polk as executive producer, Lina Alvarez as associate producer, and Chad Peace as president and co-founder.
Olas Media.
So the seminars that we do are really important to most people because they need to know how to wrestle control back from the government. It's not just for rich people. Well, you've got to come to these seminars because right now people don't realize that by not doing that, you are naked.